freedom of speech only really started to become a real issue after the Second World War, when or a legal issue, put it that way, when the United Nations declared freedom of expression to be a human right in the Universal Declaration of Human Rights in 1984. However, in the Bill of Rights, there's also a duty on states to limit free speech when certain expressions incite national hatred, racial or religious hatred, anything of that sort, and it's targeted at certain groups, and it may actually form a danger for society. On the other hand, in 1967, the European Court of Human Rights said, in a UK case, Handyside against UK, that states should not block any speech. People have the right to offend, shock, disturb the state or any sector of the population. So this is quite a conflicting view with the duty of limiting free speech, and the European judge saying later that you cannot in any way limit it. In the UK, I'll quickly go through the sections 5 of the public order, and the section 127, sort of social media limitation. Recently, the right to insult has been taken out of section 5. It used to read, or used to read that any offence that was threatening, abusive, or insulting, which was said or which displayed writings and signs or posters or whatever, would be an offence if it was likely to offend any person that could see or hear that expression. The word offence has recently been taken out after a long campaign by MPs, by citizens, by Mr. Bean. But it's interesting to think of why that came about. In 1997, you had some disturbances in Southall. You had riots in Brixton, or shortly after, and miners striking, and also rioting all over the place. Mainly being incited by expressions being indulged into these sort of riots by people, I've forgotten the English word now, but to inciting violence, basically. So or insulting groups and then getting people to get to the streets. It's been said that when in 1986 that law was developed, that the word insult, to whether to include that or not, was the most controversial part of all the discussions. And that makes sense, because insulting someone is not as bad as actually inciting complete hatred. But still, it was put in, and recently it's been taken out. The Joint Committee on Human Rights was against. Later, another group of MPs formed a new coalition against this, and really tried to persuade the government to take out the word insulting. The government didn't want to take it out, but after so much pressure, they caved in. And it has been taken out. And the last thing, you've got the section 127A of the Communications Act. Yeah. And that's basically the internet version of the section 5.
I think a lot of the legislation set up to deal with this around the world, not just in the UK, is far too blunt and broad, and I do think that it will sort itself out eventually. It's just a case of hoping that we don't get caught up in it all as collateral damage along the way, as the kind of the test of all this, the example that everyone points at, says, well, that's the reason that this all got changed, which is obviously a very real risk, and something I suppose I should really think about more when I'm blogging, because I write about technology for a living, and I do sometimes have to be kind of, I have to be critical, but when does critical become offensive? It's difficult. Am I offending Mark Zuckerberg if I say that Facebook's ad targeting is absolutely terrible?
Use the word sucks.
Sorry?
Use the word sucks.
Yeah, he sucks, exactly. Is that offensive? And Should I be worried? I don't know. But should I be concerned when I click publish on something? You know, hopefully I'm not the person who ends up being the example that's held up.
In terms of the actual question of this panel, do we have a right to be offensive? If it were, should we have a right to be offensive, I'd say absolutely yes. I mean, I work at Index on Censorship, which for 40 years has been working against censorship in all forms. And before that, I was at a project working on free speech issues specifically as well. So I'm probably, I mean, this panel is very friendly to free speech, but I'm probably even further to one side than the rest of them, and maybe some in the audience. But the question, do we have a right to offend in the UK, to be offensive? In many contexts, we don't. I mean, you mentioned two major laws. There's quite a few acts, quite a few bills in the UK that restrict this and do so to such a degree that it is infringing on freedom of expression. And it's actually definitely hurting the state of free expression, which is, I mean, you mentioned some of the political issues, but at its very core, it's a fundamental right. And it wasn't just established in 1948. It's been key to our functioning society for forever. But specifically with Section 5 of the Public Order Act, so the two things we're talking about is this Public Order Act from 1986. So yes, it's quite outdated. It's just been revised to remove the word insulting, which is really important because with that word, satire comes into question, basic comedy, basic humor comes into question. So that's a positive step. But the problem with Section 5 is that it doesn't actually say words that are intending to harm. It only looks at likely to. And the intent of what you actually say is key to what you mean by it. So if you go on Twitter and you say something that happens to offend someone and you didn't mean it to offend them, should you be prosecuted? No, you shouldn't. That's not what you intended, and it's not what the outcome was meant to be. Section 127 is another one that's key and closely related to that. And an act that's actually been used more recently and more frequently is one called the Malicious Communications Act, which is almost identical. And from that we've seen someone arrested for burning a poppy and putting it on Facebook. Police tried to prosecute a student in Oxford who asked a police officer if they knew that their horse was gay. just obviously perhaps a joke, not meant to actually mean anything. But because these are founded in public order, that's the key. So the police use these acts, they use the Public Order Act they interpret it as broadly as they can so that they can actually crack down on people's freedom of expression to preserve public order, which is really problematic because freedom of expression should be enshrined and protected above these other things and not specifically cracked down upon just so that the police can make their job slightly easier. And what you were talking about with the interim guidelines for social media, the criminalization of social media is one of the big issues that we should be talking about because it's affecting all of us. I mean, a lot of us are on Twitter. I'm sure many of us are on Facebook as well. And like you said, we don't always think before we put these statements out there. And we shouldn't have to overthink it. If we genuinely think something, if we genuinely believe it, we shouldn't be worried so much that we restrict our communication, that we restrict our speech just because we're afraid of getting arrested. One more point I'll make on this before we open it back up is that these laws in Britain do affect other countries and very dangerously. When other countries see the laws here or around the EU or more broadly than that, they use them as an example to implement laws that are much more restrictive than even exist here. When they can point to these acts, when they can point to these laws and say, look, in Britain they're doing it, and Britain protects freedom of expression, then we should also have the right to do so. It gets very problematic, and we see this in India. There's an IT Act there from 2008 that punishes sending of offensive messages all throughout the Middle East. There's laws that punish people for blasphemy or for saying things that go against public order or public morals, and it's a serious problem, and I'm glad we're all here to discuss it today.
A lot of the people who are calling for his prosecution, I think I'm right in saying this, were at least related to the EDL, to the far right. And what surprised me about that is that if I thought about the people who will most frequently be called grossly offensive, it's people at the margins or at the fringes of the political debate. And those are the people who are going to be subject often to laws that outlaw grossly offensive speech. They're going to benefit from laws they're going to be saying things that challenge our perceptions of what's acceptable. And it's right that they're allowed to do that. And it's right that we can say, you know, if we believe it, you're full of shit. You know, if that's what we think. And it just really surprises me that the people who sort of defend the prosecution of people for saying things are offensive are often the people who are going to benefit most from laws that protect that speech.
And that was the amazing thing in the Reform Section 5 Act. We saw Peter Tatchell and gay activists come together with UKIP, and these people obviously need their freedom of expression to be protected because, like you said, they're the ones most at risk for having their slightly offensive or not always, you know, positive, civilly minded statements taken out of context or being perceived as offensive.
All of us, anyone who says something. So how do you react to that? How do you enforce that? China, for example, they enforce their speech laws with huge armies of cyber police who check social media on certain keywords. Of course, they've got algorithms to filter our work or filter our posts. But they're also actively looking at what's being posted, and sometimes they delete it, sometimes they throttle access to certain speech. I was wondering from the group, what do you think about this? Are we actually able to apply these laws to